Welcome. Today I'd like to talk to you a little bit about appeals and the appeal process. To fully understand the concept of an appeal in a judicial setting, it is important to know the difference between appeals as a matter of right, such as an appeal from a small claims court in Pennsylvania, that's the Magisterial District Court, from an appeal after a trial or from a ruling on a dispositive motion in a trial court, to an appellate court in which some specific legal issues must be preserved for appeal. First, let's talk about appeals as a matter of right and the process associated with those. In many commercial collection claims, suit is initiated in a small claims court because it is below a specified jurisdictional threshold. An adverse judgment entered in a small claims court can be appealed to a court of record as a matter of right. What do I mean by a matter of right? Well, the appealing party need not allege any legal error made by the small claims court judge and need not preserve any particular legal issue for appeal. So many commercial collection cases start at these small claims type of courts, but there's no enforcement action that can be taken on these small claims decisions, verdicts, or judgments when they're appealed as a matter of right, because they are not final judgments. Appeals as a matter of right from small claims court or small claims divisions of courts of record can often be used by debtor defendants simply to buy more time, not because there is any issue that has to be litigated on an appeal. This is to be distinguished from appeals from a trial court to an appellate court. These generally result from evidentiary rulings or decisions on motions during the course of contested litigation which affected the outcome of the case, or from the court's ruling on a motion for post-trial relief after conclusion of a trial. When an appeal is filed from an order of court, the trial court usually issues an order directing the appealing party, the appellant, to file a statement of matters complained of on appeal, and that frames the legal issues that are going to be addressed on the appeal. An appellate court is not a trial court. It doesn't have evidentiary hearings, and it will not second-guess the findings of fact by the trier of fact in the trial court, whether that trier of fact was a jury or a judge sitting without a jury. Another difference, and an important difference from appeals as a matter of right, is this. If the debtor defendant appeals from a judgment against him and in favor of the creditor plaintiff from the trial court to an appellate court, the creditor can still execute on that judgment even on appeal unless the defendant posts a bond in an amount 120% of the judgment amount. This is called a supersedious bond. The bond requirement usually prevents a debtor defendant from using this appeal process to buy more time, because if he can't afford the bond, the creditor can execute on the judgment. Depending on the issues raised on appeal, the result of the appeal can be a number of different results, either affirming the trial court or reversing the trial court, or reversal of the trial court and remanding it for further proceedings. And the remand, of course, can mean a second trial and maybe second appeal from other issues. But in summary, in collection matters that start out in small claims courts, whether they are small claims courts like the minor judiciary or magisterial district court, or small claims divisions within a court of record, creditor plaintiffs can expect situations where the debtor defendant makes maximum use of the appeals as a matter of right, often as a means to further delay the creditor. In an appeal to an appellate court, unless a bond is posted, that may not necessarily be an avenue available to the debtor. Hopefully, this presentation has provided you with some useful information regarding the appeal process, and thank you very much for listening.
During the appeals as a matter of right process, suit is initiated in small claims court. The appellant does not need to allege any legal error or preserve any legal issues for appeal. Small claims court decisions are not final judgments until the appeal period has expired. No enforcement actions can be taken before the appeal period has expired. Appeals as a matter of right are often used by defendants to buy more time. Appeals from a trial court or an appellate court generally result from legal rulings or decisions during the course of contested litigation which the appellant believes to have constituted prejudicial error. The appellant usually must file a statement of matters complained of an appeal so as to identify the specific legal issues being appealed. A creditor can execute on a judgment, even on an appeal, unless the defendant posts an appeal bond of an amount of 120% of the judgment amount. The results of the appeal can be the affirmation or reversal of the trial court order or judgment, or the reversal of the trial court order or judgment and remand to the trial court for further proceedings. The appellate court does not retry the case. We hope you have enjoyed this episode of the 5-Minute Legal Master series, where expert, board-certified attorneys help you master today's important legal topics.